keep on. So let's start our webinar. Good morning, everyone. Welcome to the weekly Saturday knowledge sharing webinar organized by Mehta and Mehta. Our today's topic is insight into reduction of share capital. This is little complex topic. Not every company is doing this and having exposures. So today our panelist is Mr. Keshav Lahoti, who is Director Legal, Head Legal, Secretarial and Compliance of Indifi. He is having more than 13 years of experience into secretarial legal compliance into various industry of NBFC, finance and manufacturing as well. He is fintech and other services. He was heading, he has experience of IPO, also high-stake litigations, various legal drafting, he is a collaborative leader who consistently mentor teams to deliver excellence and strategically align legal initiative with broader business growth objective. He actively participates in industry discussion forums, sharing his insight and engaging in debates, and has received multiple awards and accolades for various projects and accomplishments. His expertise include SEBI LODR, FEMA, FDI, digital lending, KYC, AMLA, corporate governance, ESG, and capital market, IPO, FPO, QIP, debt instrument, private equity, securitization, and various contract drafting, treasury agreement, litigation, and various things. Thanks a lot, Mr. Keshav, for your time. Thanks. It's a varied experience. We will get input from your knowledge and experience. Thanks for your time. Thank you.
Yes,
As usual, we have with us our presenter, Mr. Dvip Joshi. He is a secretary legal professional with 10 years of experience in corporate legal advisory. He currently holds position as head legal consultant at Mehta and Mehta. He possesses extensive experience in managing in merger, amalgamation, in IBC matters, various spectrum of company law issues. His specialization is non-litigation corporate advisory, where he provides strategic counsel for the restructuring of the company and legal opinions and critical commercial contracts and agreement for diverse corporate clients. Thank you, Mr. Dvip. We have, as usual, our Sudhakar, who knows everyone, and Mr. Bala. Welcome both of you for your time. With this, today's topic on reduction of share capital, friends, I know many have not experienced, but it is a very interesting structuring mode a company has, when it is to be used, how it is to be used. We will all discuss and how it can help the company in a situation. This all is necessary as a CS, as an employee CS or practicing CS, the company secretary should know, so that you can advise the corporate as and when required. It has complex procedure. So we are detailing that also. You are allowed to take expert inputs from Mr. Keshav, Sudhakar, and Mr. Bala. With this, I'll request Mr. Keshav to say a few words on the topic, then Mr. Sudhakar and Mr. Bala, and then Dvip, you can start the presentation. Over to Mr. Keshav.
Thank you, ma'am. And good morning, everyone. It's a pleasure to join this webinar on this critical topic, reduction of share capital. So my name is Keshav Lahoti, and ma'am has already given the long introduction of mine. I don't think there is nothing to add from there. So we will dwell into this provision, section 66. And as a disclaimer, all these views are my personal and nothing is related to my company, just to be very vigilant onto this. So, yeah. So section 66, I hope I'm visible. So while section 66 is very concise, but it carries a significant weight and it often leads to various interpretation. Even rulings are also different and depends on case to case basis. So we'll touch upon the basically what is the rationale of being introducing this section and why there is so much of anomaly and you can say confusion, is persisting in this thing. Though we do have several case laws and things are there, clarities are there, circulars are there. So let's unravel it together. I would be like beginning this thing by saying consider a scenario wherein suppose you have started a business with 1 crore rupees. Now you require more capital, you require funds for your business, and you approach a bank or NBFC or financial institution just to lend you the money. Now, what bank will see? Your cash flows, your ratios, your solvency things, your capital infusion, skin in the game, and other factors which onto their prerogative. Basis that they have sanctioned you the loan of 50 lakhs, and now the money has hit to your account, and you now the bank has also been you can say having the exposure on your uh, business. Now you think that ultimately my 1 crore rupees is there. I why should I be like taking the whole exposure? I should be taking out some of the money because you have got it from loan. So now you think that 50 lakh has already come and now you want to withdraw it. Do you think that will that be justified to the lender that after looking at the capital, looking at the cash flows, and now you are taking back the money, your capital, and they have given you the money for running the business, but you are taking it out and considering reducing your risk exposure. For that thing, the law has introduced this section of reduction of share capital and secondly the buyback because they actually involve returning of the capital. And if you see that these two sections require some approvals, wherein buyback, if you see that some threshold limits are being provided, wherein you can be like can do the buyback with the approval of the board and then with the approval of the shareholder to some by meeting some criteria, which requires one of the condition is debt equity ratio, wherein if you see that debt is increasing considering the capital, then you can't allow, you can't do the buyback. Coming on to the reduction of share capital, it's there is nothing, you can say clear guidelines has been provided. It is onto the prerogative of the NCLT, the tribunal, wherein you can apply to the NCLT that it could be like reduction of share capital basis the reason which you are going to provide it in the petition, and we are gonna we will be discussing the whole section and the rationale of basically what things we need to incorporate. So what is the intent behind introducing this NCLT approval? So just to circumvent all the situation wherein owners actually tend to take the loan or something and then later on get the money out. So for that reason, just to reduce all these cases wherein the creditor should not be like being on a wrong side, and it should not be justified to them as a creditor as a lender. That's why these restrictions has been introduced. So to you can say increase the transparency and to you can say not to you can ads like there should not be any defraud to the creditors, disadvantage to the minority shareholders and other you can say inappropriate uh, purposes. So this we require application to the NCLT, and NCLT goes into the very depth of understanding what is the intent, what is the rationale behind it. So to set the context, I would be like, what is the core of Section 66? What is permitted? So Section 66 allows, you can say three things. First of all, your AOA should be provided for this thing that your company can take out the reduction of share capital. First one is extinguishment liability on unpaid shares. Second one is cancelling of lost capital. That is like accumulated losses. And third one is returning excess capital to the shareholder. So these three reasons are there. And I would be saying Section 61, 66 one says that capital can be reduced in any manner, which is a word which we every one tries to play with it. And but here is the catch. Do you think that does that mean there is a ultimate freedom, unlimited freedom? So absolutely not. And now it's like I would be giving some of the case laws in brief, but Dweep and other professional people, colleagues, or those who are joining this webinar will be taking that up in detail. So let's decode the judicial verdicts that define boundaries. So in Philip India case, NCLT Kolkata instituted reduction must align strictly with the extinguishment of unpaid capital or loss cancellation, wherein Vanaz Engineering NCLT Mumbai allowed reduction for administrative efficiency even without losses. So that's a variation. In my view, in any manner is not a free pass. Companies must prove a rational commercial purpose, simplifying capital structure, resolving dispute, or document the rationale in a petition is an important critical thing. Vague justification will not survive tribunal scrutiny. Next one is selective reduction versus buyback. Likewise, I have touched upon in the initially said, can a company reduce capital to exit specific shareholders? Even in this, tribunal are also split. In Brilio Technologies, NCLT allowed selective, you can say, reduction, calling it as a legitimate restructuring tool. Wherein in Philips India, NCLT rejected it and it as a disguised buyback to squeeze out minorities. So, to me, selective buyback or you can say selective reduction is valid only if the intent is not coercive. You can say resolving deadlocks, not force exits. The exit price reflect the fair market value. So not the, you can say, price should be fair, wherein NCLT don't go into the valuation side, but still considering both the parties should come onto the same page. Creditors are unharmed. So these are the principles which actually NCLT look at while delivering the judgments, and we as a professional should be cautious of all these things. Third one is securities premium account. Can companies dip into the securities premium account and to pay the shareholders? So again, in Brilio Technologies, NCLT said yes, prioritizing corporate restructuring and autonomies must. Sorry, and it can be used for reduction, but you can say somebody as a well section of securities premium account restrict its uses. It can be used for issuing of bonus issues and other purposes. So article should be allowing this the reduction of benefit. This is for the benefit of everyone. That's why using of SPA to eliminate or to you can say to use for other purposes can be like acceptable if until unless tribunal you can justify the tribunal that this is for these purposes we are using it. Coming on next one is uh, section 66. Does it mean that it is only providing the protection for creators? Likewise, law says creator can object the public notice or you can say consent within 3 months, and sub tribunals demand for a written consent even if creditors say silent. So how we are interpreting this, that meeting with the creditors, finding affidavits, confirming no objections, create a debt reserve funds or on the instruction of the NCLT and plan accordingly. Next one is minority shareholders, wherein Philips India cases, NCLT has rejected the application, and in Brilio, as likewise I said it, they have accepted on the basis of the valuation. So there is no hard and fast rule around it. You need to be like very open to understand the both the parties to let to come on to the valuation, transparency in methodology, a change in the dissenters, or you can say who are dissenting, whether you need to convince them. And fairness is something which NCLT look at very particularly, that how the scheme is been drafted and how we can it is justified to each and everyone. So yeah, I hope Deep will take you to the deep dive to the presentation, and you will feel inquisitive after having this background, and we will be like having you will be having a thoughtful session. So thank you for listening patiently. I would hand over this to Dipti or Dweep.
Yeah, Sudhakar, yeah, just few word and Mr. Bala quickly because we can start early. Yeah.
Good morning, everyone. In fact, one of the crucial decisions what a board has to take is that reduction of share capital. And very surprisingly, there is no mandatory requirement to take this decision only at the board meeting. That when technically it is possible, board can take this decision by way of a circular resolution also. Though such crucial decision is not to be taken by circulation. Technically, it is permitted, but as a director, one should never get tempted to pass this kind of resolution by circulation. Second thing is, surprisingly, unlike Section 100 of the erstwhile Companies Act 1956, under the present Section 66 of the present Act, there is no requirement for authorization of reduction of share capital by articles of association. This is also a very surprising thing because even if there is no provision for that, but by virtue of the act itself, one can go for reduction of share capital. Third question is that why capital is to be reduced. There are various reasons out there for that, which we will discuss while Dweep is making his presentation. And that before I hand it over to Bala because of the time constraint, and okay, one more thing I would like to say is that this decision of reduction of share capital, the board has to take with utmost responsibility and only to be taken for a strategic restructuring kind of decisions and not for any kind of purpose to return the money to the shareholders. At the same point of time, though selective reduction of share capital is possible, it should not happen that a minority shareholders have been ejected or evicted from the company by virtue of using this particular thing. This is what NCLT has to take care of whenever it is going to approve any scheme for reduction of share capital. It has to take primarily two segment of people's interest. One is the creditors, of course. Second thing is the shareholders. This particular petition, what is going to be made to NCLT should be for the benefit of the company. And correctly so also, no public notice is required and public hearing is not required for making approaching the NCLT to make the observations because it is an internal matter as far as the capital reduction is concerned. So I give a pause here and when Dweep is making his presentation, wherever it is required, I will pitch in. Bala, you may kindly take it forward.
Good morning to all of you. I don't want to take much of a time of the participant because we are already 11:70. But only one thing I would like to stretch upon here. What happens is the drafting of the scheme is very, very important. What the company wants to do will have to be very clear so that NCLT is able to appreciate what is the rationale behind why we are doing it. Because although as initially our panelists and many people, Ripti said, many people may not have the experience. I also do not have much of an experience except one case where we have actually structured in such a way that we have refunded the excess money to the shareholders way back in 2003 or something like that in the 1956 Act. That time, although we have taken every care because company was a very cash-rich company, we are able to justify, we have done everything. And ultimately, unexpectedly, last moment, what happened? Some of the major creditors took a serious objection and they said it should not be approved. Then ultimately, it was a difficult task for us to, again, to go into the detail and have the meeting and get it and get the no objection, assure them that, the safeguard is taken care of, company is a cash-rich company, etc. Now, finally, we got the scheme approved. So really, what we read in the theory, what is practicality is something different, which I think Deep is going to take us through what is the things. And another thing is that unless we are very clear in the drafting, unless we are very clear in presenting the things, it is very difficult. Although it is a very small section, but it has got a lot of intricacies. As we go along, we'll start exploring it. I will request all the participants, as usual, put the questions in the chat box. We'll be taking it then and there. At the end, we'll permit you to talk also. Over to Deep, please.
Thank you, Balaji. Dipti ma'am, we can proceed with?
Yes.
Go ahead.
Go ahead.
Good morning, one and all. And first of all, thanks a lot to the Meta team, being Disha at the head, and Prathamesh, and leading pioneers of Meta and Meta, Mr. Sudhakar, Mr. Pala, and ma'am, Dipti ma'am is there. So thanks a lot for this weekly webinar. So today's topic is basically reduction of share capital, and this is something that what I just as we're discussing, that this is something that many of them have yet not touched bases, or they're yet to brush up with those provisions, or there are many questions that needs to be answered, and there are many confusions with regards to, just as we discussed, just as Mr. Keshav was highlighting the recent case study of Philips India. So during the whole course of this presentation, what I'll be highlighting, or maybe focusing on, is to clear all those areas of the practical aspects as to how do we get into the process, what are the requirements that to get into the process. And I'll be dividing the whole presentation with three parts, like the pre-planning stage, the execution stage, and the post-compliances. And on the later part, I will be also discussing, some major case laws or the landmark case laws that we in our daily usage of this topic, that we have this with the NCLT. So these are some case laws that we commonly come across. So which can help clarify the doubts that many of the attendees might have. And so basically, the first slide is with reduction of share capital. This is basically the whole definition of it, and how and why is that the company taking into this consideration this whole provision as such. So we discuss as to the rationales of, or the circumstances or reasons why the company might opt for a reduction of share capital. So, one is the eliminating of accumulated business losses, returning of surplus to the shareholders, maybe when if it's a cash-rich company, which Bala sir just highlighted, that it's a cash-rich company which they had recent, which he had an experience with, then releasing a liability to pay up the capital in order to reduce the nominal value of shares, to simplify the capital structure, insufficient distributable reserves, assets to shareholders, etc. And this is one of the case laws, the international case laws, where they were the reasons were highlighted as such. So this comes into play when NCLT has certain queries with regards to rationale of merger, or sometimes what happens is the NCLT judges also, in a very conventional bench setting, like not in Mumbai but elsewhere, what happens is that for them also the process is new. And when they come up with, acha aapko ye loss ko set off karna hai, ye karna hai, that is why you're doing this. So at that point in time, such case laws or such precedents help us to make them understand as to why are we taking up this whole process in due. So this is some basic then this is all the regulatory framework that defines and in all has this framework assigned to this provisions. Then coming to section 66, as Mr. Keshav was highlighting it. So this is subject to the confirmation by the tribunal that an application by the company has to be through a special resolution, and which will reduce the capital in any manner. So now when I highlight this portion, is that your section 66 does not have any restrictions with regards to how you do it. In any manner opens up a Pandora's box that there are multiple ways to do it. There are multiple mechanisms available at the disposal of the company as to how do they want to restructure the whole thing. Now I'll tell you, reduction of share capital is not just a single of process that can be taken by the company. Rather, if they're also having a scheme of merger and amalgamation, reduction of share capital goes hand in hand to it, and they can structure the whole scheme and have this reduction of share capital in one composite scheme. So this may I don't know how many people may be aware, but that composite scheme can be worked out in a way that you can restructure the organization, and to make it at least profitable on the part that you can reduce it in a way, your liabilities in a way that can show better results or better performances of the equity wise, probably. So these are certain ways where you can have these reduction of share capital taken care of. So the extinguishing or reducing the liability of any of its shares, or either of without extinguishing or reducing the liability of any shares by cancelling any paid up share capital, or pay off any paid up share capital which is in excess. So basically this is reducing your equity liability. Now there are some certain modes of just in brief to make you understand as to how this works. So the act does not specify the method for capital reduction, as I told you, that it has given a free hand to the companies to take care as to how do you want to do it, and how do you want to structure it in a way that is suitable in your space, in your specific case part. I'm so sorry. And the tribunal has broad powers to confirm reduction provided that all the creditors either consent or paid off or other interests are secured. So I'll come to that part also. So what I will try to do is that what how this process is taken care of at the NCLT level, what are the procedural requirements we get into, and the whole process in detail at that point in time. So these are certain methods of reducing the share capital. We are with an example that we can understand is that, let's suppose if I want to extinguish or reduce the liability on shares, then by an example is that if the shares have a face value of, let's suppose, 100, with the INR 75 paid up, the company can reduce them to 75, relieving the shareholder of the remaining 25 liability, and accordingly structuring the whole deal out. Then the cancelling of any paid up share capital. That means if it is the 100 value, it is backed by 75 asset, the company can cancel the 25 per share, aligning the share value with the assets part, so that the difference is irradiated out. Then the payoff excess paid up share capital. Now let's suppose the face value of 100, and it can be reduced to 75 by paying back 25. That is basically paying back to those shareholders. Now this is different from buyback. Now reduction of share capital and buyback are two separate provisions which have their limited restrictions also in place. And how does it differ is with regards to minority squeeze outs. Now I'll come to that part also, where I'll be uh, focusing on selective capital reduction and how is it different from buyback. So I'll be touching base there also, and I'll be talking that in detail with my experience as to how we've dealt with those companies and how we've helped them restructure those things. Now there are certain conditions precedent of it, that the company is not allowed to implement the scheme if the company is in arrear of any repayments of any deposit accepted by it or something. So these are certain precedents that conditions that the company needs to follow and abide by. And these are observations that come up at the ROC/RD level at the time when the process is there at the NCLT, and when the petition for reduction of share capital is placed on record for the ROC/RD to place their observations. So we have seen many cases wherein the observations of these kind, where the company has defaulted or have a real erred in the payment of any deposits or any interest part or any of those arrears pending. So at that point in time, we have seen cases where companies' petition have been rejected on that part alone. Then there's a certain case laws that we generally refer to where it comes to this conditions. So one is the Exxon Patent Packing and Rubber Company. For a company to reduce its share capital in any manner set out in this section, it must have the power under the Articles of Association to do so. So a lot many times we also have to amend your articles to incorporate but now the general follow is that companies generally follow this articles where they already have those provisions in. So that is a less treaded path right now. So coming to the NCLT procedure, now this is where the practical part of the whole thing comes into play. Here, so now before I enter this transaction into with my client, what my certain requisites are to understand. So this is from a very very consultant point of view, wherein when I get into contact with my client for the first time, my understanding of the whole transaction is as to why are you doing this, and how can I help them clarify on any parts that they need clarifications on. So basically, when I get into this conversation, the first question I ask is, how many creditors are there, or what is the ratio, what is the secured creditors, what is the unsecured creditors ratio, how easy it is for you to get those consents in place in case it is required. So I'll tell you the concept of consent also. So consent basically are two types. One is your affidavit of consent, and one is a normal consent wherein you take it on your letterheads of the creditors. Now if the corporate is a huge one, it will have creditors volume, a very high volume of it. Now let's suppose they will have to 2,500, 5,000, 10,000, 20,000 lakh creditors. So in that case, getting the consent from each of those creditors through a affidavit form is a very, very, very a process that is almost impracticable. So at that point in time, he rather suggests कि सर एक काम करो, मेरे को NCLT convene meeting का ही मेरे को आप direction ले लेना. So what happens is that it gets easier for them to convene a meeting rather than taking their consent. But in a very closely held company, closely held private company, therein getting the consent of the creditors might be easy, but also we face challenges when it comes to the even in a closely held private company, the volume can be up to 10,000, 20,000 creditors. So at that point also what we seek is that you have to serve notices to each one of them. And when these notices are being sent to them, so the admin cost also to send those creditors is a lot. So now let's suppose the printing cost of those creditors. Now imagine sending a 3 or 4 page document also to 10,000 creditors of yours. That is a huge admin cost for you. So at that point in time, what we practically give solutions to my client is that we can seek dispensation from serving this notice to the creditors, with creditors having less than 1 lakh. I mean, if let's suppose I'm seeking dispensation from NCLT stating that creditors above 1 lakh will be served, because now when I say unsecured creditors, my top vendor to almost my chai wala is going to be covered in that unsecured creditors. So at that point in time, I seek a dispensation from the NCLT stating that only allow me to send this notice to creditors who are beyond or more than 1 lakh. So that also gives certain relief to that corporate debtor. I mean the corporate client, that they see कि चलो सर इतना तो एटलीस्ट हमारा वो बचता है. So that is also it helps majestically for them. Then this application, so firstly we discuss this part, and then we come to the scheme part, wherein we send in the scheme, we discuss them, the valuation report of the whole transaction, the financials has been discussed. So based on that, we provide many solutions to it, and companies come to us with certain requirements. Like for an example, for a very recent case, that they were seeking. Now there was one company whose holding company was, let's suppose, X, and that X holds 99% in that company, and there were only 1% of shareholders who were outside the company. Basically they were ex-employees of the company and current employees also. So the company had tried everything to get them squeezed out from the company. They provided them buyback options. They provided them with much more settlement options to give up those shares. So this was a public shareholding company. So they tried everything to do that. Then somebody recommended them that a provision under 230(10) is also available for at disposal, where you can seek out this minority squeeze out. Then they came to us. They discussed this कि सर हमने सब कुछ try कर लिया है but ये नहीं जा रहा है. So at that point in time, to discuss this with them, they were adamant on the part, नहीं sir हम 230(10) में जाएंगे and we'll take over those minority shareholders and everything. So at this point in time, I came to know that companies are not aware that such type of mechanism are available at their disposal, where they can selectively reduce the non-promoter shareholders here. So we suggested them, we presented them with certain case laws, we presented them with many facts to the matter that such scenarios are possible, to which their disbelief, they thought, no, this is not something that that will be advisable, because we don't know how sure it is that how does this get through. So at that point in time, we had to explain it to them that this capital reduction, when you view it from the capital reduction point, you view it from a very very limited perspective. But as I highlighted, that this can be done in any manner. So there are no restrictions as to how do you want to reduce it, and this is how it differs from buyback or any other mechanism available at the disposal for minority squeeze outs. So this is a prime tool for the companies to get this through, and then we presented them with certain case laws. They understood the the facts of the matters, and then got in place कि अच्छा सर आपने अच्छा वो बता दिया, so at least we can then think through this, and we filed an application, and then we got through the admission part and everything. So telling you my major reason for telling you this is that when I say specific non-promoter shareholders can be selectively reduced is to the fair point that you provide them a fair and just value to the exiting shareholders. That I'll also come to as to how the tribunal interferes with the uh, this selective capital reduction process, and how can we work throughout, and what are the general principles that have been laid down by the Supreme Court itself. So everything I'll be touching base to with just the progress of the company. I'm so sorry.
Can you switch on your video?
Ma'am, I tried that, but again, like last time, I don't know this laptop.
आप चमक रहे हो.
Again, yes, correct now. So
Yes, problem is white ball give the spark.
yes. So now coming to this application filing state. So once the scheme is in place, the valuation report is in place. We then go ahead and file this draft this application, and this application is so NCLT for the people who are new to this litigation part. The application uh, drafting filing is very pro forma based filing. So this is unlike the civil and the criminal part where जहाँ पे आपको literally stories लिखनी पड़ती है, there are novels written in the application. This is not the case here. NCLT drafting and filing is a very pro forma based filing and application, which is very restrictive to the facts, very strictly limited to brief facts of the matter and the specific prayers accordingly. They do not want you to tell a whole हम जैसे बोलते हैं पूरा गाथा लिखने आपको जरूरत ही नहीं है उसमें. So that point in time, this is how the application is very crisp, very brief, and to the point. And so this is basically for the anyone who's new to this litigation part. Then once this application is filed, this goes on to the admission stage. Now there is a process for registering the application, removing all the objections. So this is a very procedural thing that when we file at the NCLT, once the application is filed, then it has to be scrutinized by the registry. Then there are certain objections raised at the petition that इसमें कुछ missing होगा, या if there are certain requirements of the NCLT as stated which are not complied with, so they give you 7 days time to get through, and then your application then gets registered and listed accordingly. So this is basically the process followed by the NCLT, which the advocates or the generally appearing advocates are aware of, and they handle the process very smoothly. So in this, so there are also delays. I don't know how many of you are from the corporate side who have faced many problems with registering it or the filing it, because I've heard many complaints from my clients that sir हमने file किया था 2 महीने पहले, अभी तक हमारा registration listing नहीं हुआ है. So to answer to those queries, your advocate needs to be thoda a bit very active to communicate with the registry and to get through things, and we'll have to work it out that way. So to solve those issues, it is only on the advocate's part to do something, because I've had clients where they say that sir हम लोग कुछ कर सकते हैं क्या हमारे end पे, but मैंने बोला आप कुछ नहीं कर पाओगे, आपके advocate को ही you'll have to be at the front runner in this part. So once your application gets listed, you have to provide the physical documents at the NCLT, and at the time of hearing. So now, for those who are not aware, the hearing takes place through two mediums. One is the physical, and one is the VC mode. And during this mode, during the first initial hearing, the court tries to understand the rationale behind your transaction. The court the tribunal looks at this transaction in a very fishy manner. They will ask you 10 questions with regards to your financial standings, your financial statements, your transaction based statements, everything will be listed out. There are certain documents that are required, along with the application, that the list of shareholders, the list of the creditors duly certified uh, by an independent CA. Then there's an accounting treatment certificate that is required under Section 133 by the stat auditor of the company. So these are specific requirements of the company that I think that have been highlighted in the progressing slides. So these are certain documents, that the company needs to be prepared with before we go into this application filing and everything. And now when
Deep,
huh,
Deep, in some of the high courts, some of the NCLT, although the law says, a chartered accountant certificate, they still insist it should be certified the statutory auditors of the
correct.
company.
Correct, sir. Correct. So, as I discussed, that this is a recent thing that the NCLT. So, as per the provisions of the 133, the accounting treatment certificate is by the stat auditor. There is no open end communication to that part. But with the requirement of list of creditors and list of shareholders duly certified by a CA, so that is still an open ended thing, and that is how now my question to my client is, okay, who is your auditor? Is it Deloitte? Is it any of the big fours that there are there? Because what happens is they are so everyone is now aware that if I have to get something from those big four, I will have to take in at least 2 weeks, 3 weeks time, so that I can arrange for, because that is the time taken by them, and this is whatever be the reason at their disposal, but this is the reality of it. So when this comes into aspect, I suggest my clients that चलो आपको accounting treatment certificate लेना है आपके auditor से, if it's a big four, then you plan your whole timeline according to accommodating that delay from their end, and then do it. But with regards to the list of creditors or list of shareholders that are required, you get it from an independent CA, not necessarily from your stat auditor. So this has been a practice for a very long time at the NCLT. But recently we have seen cases, where the NCLT has directed the clients to get it done through a stat auditor only. But this is not in every case, sir. This is very peculiar to the case where they feel something is wrong, or something is very fishy, or something is very doubtful with regards to that procedural requirement. So this is a very peculiar case where they would seek a stat auditor being, a stat auditor certified certificates. So that way, I feel that is a very, very peculiar requirement, not necessarily a generalized term nowadays, at least. So
Yeah, you're right,
actually,
actually. In fact, it differs from NCLT to NCLT.
correct.
That is number one. Some of the NCLTs are insisting, some of the NCLT, they are accepting it.
Yes, correct.
But again, coming to practicality and what is written in the book,
Correct.
that actually different, because the whole idea
Absolutely.
is drafting the same, presenting the way in which it is they understood, then
Absolutely.
that matters actually. That is what I said in the beginning. Yeah.
Absolutely.
But
This
one
will
thing
be
is that you have to keep in confidence your statutory auditor.
absolutely.
See, they are going to be there, they are going to go. So you cannot keep them out. This I always advise that please don't keep them out. You have to take in confidence. You are, working with your figures and all that, what accounting treatment, that is very crucial. They should be convinced. Yeah,
Not
only thing that cost and process in case of big chartered accountant, it's the call of the cup.
correct.
Yeah.
And
Yeah,
ma'am, just that,
if we are, if we have a big four, then to build in that timing of the cushion, whatever the time they take, because it is their procedure. We can't do anything with that, because if we want to get, we'll have to get it done. That is the way they work actually. So when you are drafting the scheme, as Deep sets it very clearly, you have to have that time frame in your mind. This
correct.
scheme is not going to get through by this time. You'll have to provide that timing. Yeah.
And sir, why I'm also focusing, see, whenever I come to the client's place, tell them what my intent is, as I discussed even in our earlier webinar last time, that companies are heavily dependent on the consultants, that they will guide us through, they will tell us this. I'm not saying no, we're not going to guide them, but I want them to be prepared internally with parts. That what happens is, now let's suppose I just gave an example last time, that in the merger of scheme they were not aware कि सर हम क्या रखे appointed date, हम क्या रखे, इसका क्या कर सकते हैं हम लोग. तो मैंने बोला, सी, दैट आई कैन सजेस्ट यू, मेरे अकॉर्डिंगली, मेरे इफेक्टिवनेस के लिए आई वुड सजेस्ट कि रिसेंट वाला 1 अप्रैल 2025 रख दो. इट इज द इजीएस्ट थिंग फॉर मी टू डू. बट यू हैव टू डिसाइड internally with your teams aligned strategically, that what is the most beneficial or suitable to your specific requirements, so that I need you to synergize with your own team, accounts team, the finance team, the legal team. Everyone needs to sit together to decide as to how do you want to take this ahead. But what happens is that we've seen the clients being very heavily dependent on the consultants to tell them this. So at my part, I say that I have a very limited scope in advising you as to how do you want to get it through until I know the management's decision here. So, and also just to take that in consideration, I have a very limited span of attention at the time of hearing. See, sir, believe it or not, or let's face the reality in the part that the litigation side is overly burdened with the applications, and each day there are 50 to 60 matters listed before the court. The court timings are such restrictive that it is not possible for each of the cases to be heard at length or in detail. So I have a very limited span of attention on that, the court at that point in time. And if at that point in time I am not clear with my instructions from my client, or if there are any document discrepancies there, so it automatically stands adjourned to a next date. Now the next date can be 1 month, 2 months, 3 months. So I feel that at that point in time I want to be so prepared that I don't, and see, it looks like चलो 1 month का date है, 2 महीने का date है. But if you look at the whole process in general, the delay or the time taken during this litigation, in the end, does not give you the result that you intended at the initial start of it. So that is why whenever I get into touch with my clients in the first meeting itself, I tell them, okay, you be proactive on the part that you give me those instructions very clearly. And if there is any document discrepancies there, I would require them before the date of hearing, so that I am prepared with, and we get an effective date rather than shifting it out to other probabilities happening. So this is one very important aspect, and this may look like, because now there are conventional benches. I mean, Mumbai, Chennai, Bangalore. They are certain benches that have been the exposure of many applications filed differently. But there are also other benches who have not yet come through this processes, the reduction or the selective capital reduction. So these are more of the conventional benches that are difficult to get away with these admission parts. So at these specific benches, I always heavily rely upon my clients to give me those clarity in advance, so that I can place it before them, because I already have a task with me to make them understand the process first, and then get it through. So at that point in time I need to be prepared with. And when it comes to this part, wherein the big four, why I'm saying that timeline is, now let's suppose Chandigarh bench gave me 2 weeks to file that list of shareholders or list of auditors, list of the creditors by stat auditor. Now to get me that process within 2 weeks, to file it with the NCLT, to get it procured by my auditor, this span of time is too less. Then again, what happens is, on the next day I just go and present there myself, stating that, sir, we need one more week for presenting the whole thing. So that is why I'm saying that we need to be very well prepared with, or very well communication network needs to be prepared while we before we file this application. Now in the initial first hearing of the as I told you, that there are, many questions asked by the NCLT with regards to the whole transaction, and to make them, convincing them as to why are we doing this, and if it's specifically if it's a selective capital reduction where I'm only highlighting on very specific set of shareholders to be, reduced with. At that point in time, there is a very conservative approach by the benches that as to why are you doing this, and you give us the explanation. So there are certain case laws that we rely upon that needs to be highlighted to them, and everything then, then goes through the process. So here is a very small procedural, aspect to it. Then once the notice and direction by the tribunal, so within 15 days of the application, the tribunal will issue notices to central government, the ROC, the SEBI in cases of listed entity, the creditors of the company. So sorry. And through these notices, they will be seeking representations and objections. These directions for notice also have to be done in a public advertisement within 7 days of the order passing, and this will be in one leading English newspaper and one, a local language newspaper, which has a nationwide reach. Then there'll be confirmation on dispatch and the publication and everything. So basically, here after the application is admitted to the NCLT, the NCLT is then going to place this application with the ROC, RD, SEBI, and all of these statutory authorities for their representations, observations, and objections. And this is a very tricky part, where the ROC, RD have been taking stands, taking objections of varied types, wherein, to deal with the stat authorities at that point in time is another task altogether. So here, what happens is once they have been served, they send you a list of documents that are required for them to, conclude the whole transaction. So they will raise certain queries that you need to respond with in time, so that the effectiveness of the whole process is taken due care of.
Basically, your compliance of corporate action and all the filings should be perfect and completed. That you have to ensure, otherwise there will be issue.
Correct. And
not only that, if you have any issues with ROC, it is a big problem to get over with ROC, because unless until ROC problems are sorted out and they won't give a no objection, that is one thing. And second thing is ROC things doesn't work automatically. You have to make a number of follow-up things. You have to ensure the things happen. That is a big hassle with ROC.
Correct. And so also, no matter how many times I confirm with my client कि sir कोई आपकी ROC inquiries है, कोई non-compliances है at your part, they at the time of, planning stage they say नहीं sir कुछ भी नहीं है, कोई issue नहीं है. But as soon as we file this with the ROC RD, we get a set of observations that, even the companies took taken a surprise beat, so that acha ye bhi tha kya, acha, so we'll have to answer to it. So all these things, it come at that stage, and then that comes a tricky part. Now how do I prepare with something unforeseen or unplanned at that stage? So this also derails the whole transaction very hugely. Now there is a 3 months period provided to, object to this, and if a statutory authority given 3 months, they will dig into everything. And if there is a certain corporate with जिनका थोड़ा track record है ऐसा, they will get into each details, and even if there is something very minuscule about it gets tenfolded at that point in transaction. So to make them understand or take their NOC from that part is a very very crucial stage that I feel, because these reports are everything. In the end, the tribunal is only going to heavily rely upon ROC RD to give their reports. If they are okay with it, 99% everything is approved.
Deep, I want to ask you one question to you. When you say the advertisement is to be released in the English newspaper and one of the vernacular local newspaper,
Yes.
I saw some of the advertisement, not only on this matter, but some other matters also in the vernacular measure, regarding the board meeting, dividend declaration day under LODR and other things and all. People release the advertisement in English, in a vernacular language. Is that acceptable?
So I'll very good points. So we've had this problems in our case also, wherein it was specifically given in the order. So what I do is generally I take up this from my client. कि sir हमारे पास agency है. What we will do is my team is going to take care of it. We'll send you the quotations, we'll send you the invoices, but all the execution part with regards to communication with the agency, let it be with us. And why did I start this is because we were one of the orders that was passed वहाँ पे ऐसा लिखा था कि it was one in English like a business standard or something of that sort, and one in a Hindi newspaper in Hindi in the local, and any other local language based on the region. So now let's suppose if it's Chennai or if it's elsewhere, we have to take in their regional language as well. So this happened, and at that point in time, they made English language advertisement in all three papers. Then when we saw it, we thought, this is a huge expense, sir. ये भी ऐसा ऐसा छोटा मोटा expense नहीं है. ये भी it's cost about ₹1,00,000 अगर आपको करना है. तो ये जब भी हुआ and then it came to me, तो मैंने देखा and I saw the advertisements. We generally don't see it because हमको पता है कि हाँ ये क्या इसमें क्या ही गलती कर सकता है कोई. But we saw it and then we saw कि अच्छा इसने सारे papers में English में लिखा हुआ है. And if I go to the NCLT with this part, I will have a beating there. So I asked them कि sir एक काम करो ये मैं करता हूँ, let me do it with my agency, and then we had to do this कि हिंदी में ही आएगा, and this is something that we thought this is a common sense part कि ये ऐसा ही करेगा, but sir वो इतना common नहीं होता है, and we've had hurdles there also. So this part is a mandatory requirement कि if it's a regional language newspaper, it has to be there translated there, and the agencies help you with that. ऐसा नहीं है कि आपको translation देना होता है. It is that you provide them with the English text and they will translate it at their own end and then just send it to you for confirmations.
So ideally, it should be in the local language. The local language only should be released. It should not be released in English.
Absolutely.
That is the gist of it. Yeah.
So once that I will just come to this part. So this is just a stepwise plan, the preparation of the draft scheme, checking of the articles of association, wherein we need to amend these articles, the preparation of the scheme, then the board meeting approval, the calling of the meeting, the convening, then the general meeting. Now, sir, I also have questions with regards to holding of the general meeting and how does the special resolution work. Now, sir, I am not a secretarial expert with regards to that, but what I understand and what I advise my clients in this particular part is that whoever is attending, I mean, sir, Bala sir and Sudhakar sir, I'll need your inputs here. That now my client questions are that let's suppose sir मेरे पास that now let's suppose I have that case wherein there are, let's suppose out of 100% shareholders only 70% of them are attending, and out of that only let's suppose the 50% of them approve this, or let's suppose 75% approval nahi milta. So their queries is कि sir सबको आना पड़ेगा. What is my general advice to them is that whoever is attending the meeting and voting is the only part that has been counted. Is my understanding at that part correct? Sudhakar sir?
Yeah, that is right. Only see, you cannot expect everybody to attend. You cannot make it compulsion.
Correct.
Only those people who are attending that particular meeting of the creators, and out of that, I mean, the people who are casting the vote, if it is a special resolution, obviously two-thirds of the voting is required.
Correct. So that is what my understanding was. But we had certain heated arguments with my clients. So उनको क्या था डर था. So they were also having a very
but Deep, what will happen is that even if at the time of the creators meeting, the creators who are not attending, still they can approach at the time of NCLT hearing and they can object.
Absolutely. That is
So what happens is sometimes it may so happen the tribunal may give an order. Okay, those creditors who have some kind of an issue with the reduction of share capital, you please repay their debts and then you go ahead. Sometimes, that kind of decisions are also been given.
Correct, sir, correct.
Yeah.
So any which ways also to register this to all our attendees, even if you've not attended the meeting, it doesn't mean you have extinguished your right to object to the NCLT.
Correct.
You may not be available at that point in time to attend that meeting or any of those reasons XYZ, but NCLT gives you another opportunity to object to the whole process during this advertisement that takes place, and you have 3 months uh, period to object it. You all the documents that are required for you to come to a conclusion are available at the registered office of the company. You can seek those documents from the registered office of the company, and they will provide you accordingly. They have to provide you. So I
The
had
only difference in case of reduction of share capital is, unlike merger amalgamations, where anyone from the public also can approach the NCLT at the time of hearing, and
correct,
he can raise objections.
correct,
In case of reduction of share capital, the public hearing is not required. Only the people who are concerned is the shareholders and the creditors.
the creditors.
Only they have a right to object, not to the other, outsiders.
Correct,
Yeah.
correct, correct.
You are absolutely right, Deep, because the law is very clear, as Sudhakar puts it. It is only the people who are attended the meeting, out of them two-third majority. That is the law. But as you rightly said, yes, people have a second opportunity to object on the NCLT. As I was discussing to you in the beginning, that is what exactly happened in our case when we want to return the shareholders' money back. So you know what happened? The objection has been raised at the NCLT at the time of hearing.
Correct.
Then ultimately we have been given the instruction, you sort out the issue, and then you come back. We have been given that time. By the time we actually have a meeting, etc., and not finally they give the no objection certificate. That is how our scheme got through actually.
Correct.
So that is there. Yeah.
Sir, also, but just to touch this recent, brush up with my experience now, there was this one specific query coming from the client that, sir, मैं notice तो भेज रहा हूँ creditors को. Now, when I'm sending the creditors notice, I am writing as per what is required in the law, that how much is the capital reduced, what is the after effects, everything I'm writing. But am I required to write the balance of that creditor, the balance that is shown in my books to that creditor? So for very procedural requirement of it or very litigation aspect to it, मैंने उनको बोला कि सर आप उनका जो बैलेंस है जो आपके बुक्स में दिख रहा है वो, because what he's saying is do I write that he the dash 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 is my creditor and he is having X rupees in my as shown as a creditor in my books. मैंने बोला आप ये open ended मत रखो, because what happens is creditor as soon as he sees अच्छा ये तो 4 लाख लिख रहा है, मेरा तो एटलीस्ट 5 लाख है जो मेरा रिकवरेबल इन द बुक्स, तो ही कम्स टू द कोर्ट with an objection कि he has nothing to do with the reduction of share capital. He comes to the court stating कि sir I have an objection, मेरा 4 लाख दिखा है but यहाँ पे 5 लाख है मेरे बुक्स में, which is totally irrelevant to the whole process. And what it does is it disturbs the whole process of the litigation, because as I told you I have a very limited span of attention of the court, and at that point in time if I have such frivolous objections coming in, it is taking undue the whole time of that effectiveness of that whole process. So
Dweep, the answer to your question is that it is simple. You will go with the creditors. Actually, you have to also furnish a list of creditors and the outstanding balances
correct,
as at a particular date.
correct,
So you will go as per your books of account, not as per the books of account or the different creditors. Number one. Number two, if any, suppose you are showing as 4 lakh rupees and the creditors, as far as his books are concerned, it is going to be 5 lakhs. So he may approach the tribunal, but normally tribunal should not get into all these kinds of this accounting reconciliations and all.
correct,
The tribunal will take an affidavit from you whenever you are submitting your list of creditors. Based on an affidavit, you will give it so that they will take it on the face value, whatever as per your books of account. In case of any reconciliations are concerned, that it is an internal matter between the creditor and the
correct,
company, and NCLT
correct,
should not get into all this kind of
correct.
rigmarole.
They don't. So actually, what happens is they don't get into this. But what happens is you waste those
That you cannot help, see, because what happens is whenever this kind of issue, I mean, this kind of schemes and all, when you go to NCLT, everybody will grind their axe according to his whims
correct,
and fancies.
correct,
Okay, that you cannot help. Number one. Number two, that's why you have to have a strong what's called as a person who can influence the NCLT. That sometimes the NCLT may get tempted to get into all these nonsensical issues
Definitely,
also.
absolutely.
So the person who is representing your case, he should be firm enough and should be able to influence the NCLT that your jurisdiction is only to this extent and you should not
Correct,
go beyond that.
correct. And
No,
Because
but
you see that sometimes NCLT members get tempted also.
no, what he is telling is that while sending the notice to creditors, no need to write the amount due to them. We submit
No,
this
no,
list
we
and
not
only
after.
required, not
recognize,
required.
we only recognize that you are a creditor.
Because
We
if
are
you
not.
write that, then there is a issue. So please
Huh.
don't, no need to write. Otherwise, because we give list and it is certified by auditor.
So
We
that
not,
is
Correct,
between
correct.
me and the NCLT at that
that
point.
was, yeah, got that in notice to creditors, no need to write amount due to them.
The amount. So it's not specifying the.
Correct. Deep has had a really made a very good point because unnecessarily, it is something like "Aapul mujhe maar." We
Yeah,
No,
only invite the problem.
it is just like shareholders, you are not writing how many shares he is holding. You
huh.
are not writing in the notice. You are just giving a notice. That's it. And he
Yeah,
will come and cast his vote. And as far as his number of votes and other things are concerned, you will go as per your ROM.
Correct, sir.
that's right. Yeah.
So just a point to note down if any of them are getting into it, you can avoid those things. So as I was talking about the list of documents that are required, the list of criteria that we discussed at length, then the certified true copies of the MOA, the notice of the general meeting, the special resolution passed. So here we also had cases wherein we have provided everything, the scrutinizer's report, everything has been provided to the NCLT. But NCLT in that hearing then also came up with a requirement that आपने ये तो दे दिया है, now you give me that in that specific case that jitne shareholders आए थे minority, all the minority shareholders who came in, who were present at the meeting, and I want a specific attendance report of those minority shareholders alag se. So what we had done is we had given them the whole scrutinizer's report, everything was shared as to who came, who did not. But even though if you were prepared by everything, the NCLT came up with a requirement that I need details of the minority shareholders who came into. I need their whole detailed attendance reports, and also they are voting if it was yes, no, whatever. So again, how much do you prepare of? But NCLT might come up with any required documents at that point in time. You may not know with. So rather you be prepared with anything that comes through. Then there are certified true copies of the latest audited balance sheet. So also with regards to audited balance sheets and the audited financials, I have certain queries from the client that sir हमको latest देना पड़ेगा, कब का देना पड़ेगा, what is the status. So at this juncture in 2025 right now they still ask me कि sir हमारे पास अभी तक audited 2025 का नहीं आया है, 2024 का है. So I still what I suggest them is that you be prepared with the provisional financial statements up to March 2024, March 2025, because what happens is NCLT may allow it for the initial first two hearings में सब कुछ देख लेगा. But so I sir also just to discuss this, I've also had a recent brief of where everything was done. The matter was an old matter which delayed due to the litigation aspect. जिसमें हमने 2024 के बैलेंस शीट्स दिए, नहीं 2023 के बैलेंस the audit financials we had given. The NCLT had reserved the orders, everything was done, and we were about to expect the pronouncement of the orders. But at another hearing scheduled, वहाँ पे उन्होंने they kept it for clarification. Now clarification was they wanted the latest financials of 2024. So I said it was a merger and amalgamation scheme. So we tried to convince them also that we are about to file the second motion petition as well, and we can attach those documents there. But they were very adamant on the part, नहीं नहीं हमको अभी चाहिए. So at this point in time, you also have another 2-3 months delay, just because in the initial phase of it they did not recognize कि हमने. And also what has happened is it was a litigational delay. We had filed it in 2023. It did not come up for hearings for that matter, and then in the initial phases they did not recognize that they wanted the latest financials, but in the final hearing pronouncement ke time pe they realized कि अच्छा हमको चाहिए latest financials. So this has also caused a huge delay. So what I suggest to my clients is कि you be prepared with a provisional statement also. You file that also. आपके पास भले ऑडिटेड जब भी आएगा तभी आप दे देना, आरओसी आरडी ओएल जो भी आएगा उस टाइम पे, बट you be prepared with the provisional financial statements also, because these unforeseen circumstances can create a huge delay. Rather you be prepared with those documents. So anyone or anybody who's having these doubts as to हम क्या करें at this point in time if I don't have that audited, you be prepared with the provisional financial statements of the latest financial year. Now the minutes of the proceeding at the general meeting where the special resolution was passed. This is basically the requirements of the whole the process. Then the notice issuance, then this is how the publication that we discussed. Now as I said, they get a time period of 3 months from the publication date, and the creditors or any other statutory authorities who want to file their objections within that time, they can do that, and all the available information that they want with regards to the transaction is available at the registered office from 10 or whatever the working timing of the office are, but till 5 p.m. Now, as I told you that there are representations from ROC, SEBI, or RD with regards to their specific transactions, and for this part, what I want my client to be ready with is, if there are any non-compliances that you feel can hinder at the time of this process, I want them to be highlighted to me so that I be prepared with those answers. I be prepared with those reports as to what do I place with them. And my advice to the client is that before you get into the transaction, you kindly clear it, or rather file an application to clear that non-compliances with the specific authorities, or you give at least a clarification letter as to how or what is your stand on it, so that things get easier to communicate at a later stage when these observations come in. Now I know that it is not something that you may know everything, but I have seen cases where ROC has been sending notices to the company for the past many months, but that have been somehow missed or not replied to, or not adequately answered to. So I would rather suggest to my anybody watching that you kindly have that in place, be it so reduction of share capital में तो ठीक है, ROC RD है, but in scheme of mergers and amalgamation, similarly वहाँ पे there is OL offices concerned, the income tax coming in, the GST departments coming in, they can create a huge impact on such schemes. It can create heavy impacts on your final orders. Now once this has been filed, the observations are answered, the reports are in place. Also, I'll just give you a small practical aspect. Now once the ROC RD files a report, you need to reply to those observations. You need to give them certain affidavits, undertakings as per what has been mentioned in the in the report, and accordingly they will then file a supplementary report if required, and then you'll have to again answer to the supplementary report, and then finally the matter will be heard at the final hearing of the NCLT. So at the final hearing of the NCLT, the ROC-RT's representative will come into the hearing to give an affirmation to the part that okay, we are okay to go ahead, we have no certain objections, or we leave it to the merit of the NCLT to decide as to how they can take ahead with those observations. Now if the NCLT feels it is okay, they will pass an order, then we'll have to file it with the NCL from the ROC INC 28 mein file ho jayega. But if not, they will reject the order. Then you will have the stated appeal forums for having this repeal or something. Now this is where the key regulations of LODR comes into play, wherein you'll have to submit a draft scheme for no objection certificate, no filing with the NCLT without NOC from SC. This NOC will be valid for 6 months. So we also had a recent query with regards to NOC. Dipti ma'am, if I can just highlight that, so there was
No. Vip, Don't
हाँ
do.
ठीक so sorry. So here it was just the reduction of share capital and the arrangement read together with the company at 2013. This is general insight to it. So here the NCLT had rejected a scheme of amalgamation on the ground that the reduction of share capital required separate set of procedures to be complied with, which with specific rules had been framed and hence could not be brought within the confines of Section 230, which was more of restructuring businesses. Hence, the applicants should file an application on relevant provisions, not under one present under which the application will be preferred. Now, this is where, when I talk about a composite scheme, started. Now, firstly, NCLT was, in a very conventional setting. They thought that reduction of share capital cannot be combined with a reduction with a merger scheme, and that it should not be it should not be combined with the scheme of amalgamation merger. But that's not the case. As I told you, that can be taken care of in a very composite manner in a composite scheme, and that can be structured accordingly. This is an option available at the disposal of the companies to take care of. So that is the case. Now also I had seen some comments from one of the attendees that difference between the alteration of share capital and capital reduction of share capital. So this is basically the difference as to how this is different from alteration of share capital. Now alteration of share capital does not require NCLT approval. What is happening is here the whole structure is changed, but there is no impact on the share capital in value parts. So here is where how you can alter your share capital without having the NCLT approval for it. So one is by increasing the authorized share capital, that is by altering the capital clause in MOA, or by consolidating the larger amount, or by dividing in form of that earlier price of, let's suppose one share was rupees 10, and now the company can increase that per share to rupees 50. So basically in crux, nothing in part of the capital changes. It is only you changing the altering the share capital in other convenient parts. So these are basically the differences. I don't know if Sudhakar sir, if you want to, or Bala sir, if you want to just highlight something on it. So reduction of share capital is the basic difference of it. So I think if that question that the person had can be answered, here.
See, reduction of the share capital, what you do is you actually cancel the share. In case of the buyback of the share, you actually buy the own share from the shareholders at the paying the money.
Correct.
No, in case of reduction of share capital, also there may be a payment also can be made to the shareholders. These are two different things, buyback of shares and reduction of share capital. Okay. So it's always, by the company, the board has to make a strategic decision. They have to take it to go for which route they want to adopt it. In case of buyback, what happened is there are certain limitations are there. You cannot just go for buyback of the entire capital. So per financial year, how much you can do it, and overall how much you can buy back, the threshold limits are there, which is not the case as far as the reduction of share capital. In case of reduction of share capital, if it so requires, even the 100% capital can be reduced also, provided you have a decent justification for that particular purpose, which is not the case with buyback. So these are all two different schemes altogether, and for different purposes, you have to adopt different strategies.
Correct.
And number one. Number two, when you go for reduction of share capital, there is no need for you to touch the authorized capital. Authorized capital may remain as it is, as it was, whatever it is there. So the only thing is in case of reduction of share capital, what is happening is your paid up capital is coming down.
Correct.
Yeah.
So you are absolutely right, actually, Sudhakar. What is the company want, they'll have to decide, because the law gives you a number of framework. Yeah, as you rightly, Satama, there's a buyback of the share is there. then again the reduction of the capital is there. Not only that, beside that, there's also a compromise and arrangement. If you want to have a specific arrangement with your shareholder, your creditors, other people, etc., you can go that section 230, 232, 234. Those sections also
correct.
you can go. So what the company at the end, they want to achieve it, how they want to restructure, how they want to go about it, they have to decide. Yeah.
And similarly, you can go for selective reduction of share capital. You
Correct.
cannot go for selective buyback.
Correct.
So it
Correct.
all depends,
Correct.
what sort of strategy you have to adopt it. It all depends. Similarly, the way Dweep is mentioning, when you go with the scheme to NCLT, there may be it may be a time-consuming exercise. Whereas in case of buyback, it is not so. Because in case of buyback, there is nobody can throw a spanner into the wheel. Whereas in case of reduction of share capital, which you have to go through the NCLT route, at every stage, somebody or the other may poke his nose into that, and it may unnecessarily lead to wastage of time. That you can't help.
Correct.
Yeah.
So now coming to the selective capital reduction that we're talking about, as I told you that companies are looking at reduction of share capital not in a very very conventional approach that it has to be specifically reduced or generally reduced. Here I wanted to just highlight that this can be targeted reducing of shareholders, wherein that can be also available at the disposal of the company's strategies. And as we were talking about, since we were talking about that Philips case, that that was a very recent case study. There there were many things, many aspects open. It is like a Pandora's box being opened, because we have a number of NCLT precedents stating that any uh, any capital reduced selectively also can be worked out, because the provision mentions expressly that it can be done in any manner. Now, in the Philips case, there were certain aspects that were not answered by the NCLT, not clarified by the NCLT, in the regards that now I'll just highlight as to where the NCLT part comes into play. Now, let's suppose X company decides that I want to reduce my non-promoter shareholding by whatever. Now, let's suppose there is a promoter shareholding of 95%, and the rest 5% is held with some other non-promoter shareholders. So that 5% can be specifically reduced with the only condition that a fair valuation is provided to the shareholders. Now, NCLT's role is a very limited role. They are there only to monitor the part that the exiting shareholders have been provided a very fair valuation to their shareholders. Even to object, the shareholders can only object to the part that I am not paid in a very just or a fair manner. Now, just to answer this part, I'll come to the NCLT decision here, wherein it was a guided principle given that it was a Supreme Court judgment which said that there is a certain guidelines available at the disposal of the NCLT, that they have to only get into the fair valuation part. They cannot also they also cannot enter into the valuation aspect of it, because the NCLT is not an expert into that, and NCLT is not going to get into the details as to how is it valued or how is it has to be, because that is a very domestic matter of the company as to what they want to do with those shareholders. So even if that minority shareholder comes to NCLT for an objection, he can only have a limited objection with regards to the fair valuation. So now in that Philips case, what had happened is the methodology adopted by Philips, the company's registered valuer, was a DCF methodology, and the shareholders valuer adopted a company comparison method. This is another method that comes in. So at that point in time, the shareholders value was far more than what the company's value was. But NCLT, I don't know, far treaded its own jurisdiction to the part, but they rejected the petition stating that uh, this is not done. This minority squeeze out cannot be done, cannot be worked out, and it cannot be done in that way. So this again led to many eyes rolling that how is this possible when there are NCLT precedents, there are Supreme Court judgments to it, that the principles have been laid down. Still the Phillips case was certainly mishandled, or something, or that information was not correctly represented by the advocates there. I feel that would be the case, because it is a very crystal clear matter, laid down by the Supreme Court also, that NCLT is not going to get into the details of the valuation aspect of it. The only primary objective.
In fact, Deep, just like I would like to add one or two things here.
Absolutely.
As you rightly said, in fact, NCLT should never get into the valuation part.
Correct.
And similarly, if you see in the merger amalgamations also, they never get into that swap ratio related issues.
Correct.
Because before you approach the NCLT, the special resolution is to be passed by the shareholders. Okay.
Correct.
So once the shareholders is approving that, unless until there is a blatant error is there, or there
Absolutely.
is a kind of a fraud is there, if you are able to establish before the tribunal, it may be examined, but you cannot just challenge the valuation and challenge the swap ratio, whatever is decided by the board or and ultimately approved by the shareholders.
Correct.
Yeah.
So that is what
Maybe Keshav could add something regarding the Phillips case, because going through the Phillips case, I read it long time back. What it appears to be, the NCLT has actually said that this particular is actually circumventing the provision of 66, and it is not, it is out of the purview of the 66. That is the reason why it is rejected. Perhaps it appears to me, to my mind, correct me if I'm wrong, if they would have gone for the buyback, that would have been far better. But instead of the buyback, they probably used this section 66 and gone by the capital deduction method. That is why the whole issue has come out with a valuation. Keshav, I request your feedback on this.
Absolutely right. And that is what I stated in the beginning, that minority squeeze, wherein they just want to get the remaining shareholders get out of the company basis the valuation they have determined. Considering valuation, since tribunal has got into cross its jurisdiction by stating that the valuation is not fair enough or equitable to all the people, but you can say the judgment which they have given it to them, by they have actually NCLT have gone behind the intent, that what is the intent of this scheme, and to uh, to be fair and equitable to all the people, wherein the valuation which has been did by the Philips India, wherein they have hired KPMG, and then they have obtained fairness value also, which ICICI Securities has given it to them, and what the shareholders have got it through the method. So NCLT has said it that both the methods are fine, but why there is so much of gap, considering these anomalies between these two valuation. So they have actually determined that you are trying to basically take the benefit of this section by filing this thing and getting the shareholders out
by not paying them adequately.
By not paying them adequately. Even at the time of delisting as well, while Philips India was listed and got delisted in 2004, and that problem also came at that point of time as well. So, since considering the company's historic background and seeing all the facts and things, so NCLT have passes the order onto that piece.
So basically, what had happened is 95%, I feel, it was the promoter shareholding in this matter, and 5% was from the shares that were delisted. So basically, this company got delisted, and after that, there were certain shareholders continuing that 5% holding. So what Philips came up with is that I want to selectively reduce those non-promoter shareholders. Now, at that point in time, if they had provided an adequate valuation to it, this would have not occurred only in the first place. Because I have seen companies who want to desperately get those non-promoter shareholder out. They would rather say, "Ki, sir, agar iska 1000 value hai, I am ready to give them 1200. But I want them out. Because if now, let's suppose I'm a public holding company, a public company basically, and if I'm a wholly owned, I want to be a wholly owned subsidiary so that I can eliminate certain administrative compliances, certain compliances. I don't want to incur those costs. Let's suppose being appointing an independent director or of that sort. So if I want to avoid that, I need to be a wholly owned subsidiary. So that benefit I'm not getting because I bloody have those 5% shareholders, and they say that they are any which was not relevant. I have seen cases where those shareholders were refusing, so the company has tried buyback. They've done everything, but that shareholder is saying, "Sir, हमको है ना company से emotional attachment है." This is these are the statements from those shareholders that हमको company से emotional attachment है, and that is why I'm not ready to give up. But that attachment is costing them a lot of cost to the entity itself, and they are not ready to do that. So here the company becomes too desperate to get them out. And at this point in time, they सामने से are saying कि भाई सर हम लोग अगर ये 1100 का वैल्यू है मैं उसको 1200 देने रेडी, but they need to be got out of this. And when Bala sir said कि उसने buyback select करना चाहिए, सर buyback में option क्या है? They still have an option to not redeem those. Correct. They still have the option to not give up those shares. So here they have that advantage. Here it is a compulsory acquisition through selective capital reduction. What they do is ये तो हमको लेना ही है. And here NCLT itself has a laid down principle stating that, sir, this is a domestic matter of the company. This is what I decide as to how my company is going to run. It is being decided by the majority of it. I don't want that minority to huckle me up in certain big decisions that I want to take. So, I think you wanted to say
Ultimately, what is to be presented to the tribunal is whatever the proposal which has been put before the tribunal is for the benefit of the company, not at the cost of any shareholder.
Yes.
Okay, means what?
I concur with you.
The majority shareholder should not suffocate the minority and throw them out.
correct.
At the same point of time, also it is the responsibility of the tribunal to ensure that this minority shareholders should not suffocate the majority shareholders also. They should not blackmail them virtually. Ultimately, what is beneficial to the company? Suppose, say, for example, if the majority shareholders, as in your case, you said that 95% is with the promoters and 5% is with the minority shareholders. When they are trying to go for selective reduction of share capital, if fair price is being given to them, then what is the problem then? So it is there the tribunal has to apply its wisdom. What is beneficial to the company, and accordingly they have to decide upon it. In fact, in case of Reliance, also about 3 4 years before, we have done one case of reduction of share capital in the same fashion. The company has come out with some kind of stock options, and ultimately that was a very minuscule, not even 1%, less than 1% of the shareholding. And for some obvious purposes, by that company has to become a wholly owned subsidiary company so that it will be beneficial to the company on various aspects. So ultimately, it went for the reduction of share capital. That suppose out of that minority shareholders who are there, out of the minority, majority of them has accepted. Almost 90 to 92% of the people have accepted it. Only about 5% of that minority shareholders were still doing that, but ultimately tribunal has accepted that proposal.
Correct. And sir, I feel it was hugely misrepresented. The whole Phillips case could have been handled much better at that stage. I don't know if we don't know the details about it, but I feel if it was adequately represented or the documents were in place, this wouldn't have been the case. Because sir, now let's just discuss this Brilio Technologies, wherein NCLT in its first instance had rejected the application of selectively reducing the share capital, but later on NCLT upheld the decision stating, I mean, they reversed the order and upheld the selective reducing of those shares because stating that it is a very domestic matter of the company as to how they want to take it up. And if the fair valuation has been provided to those minority shareholders, it is none of the concern of the NCLT or any other person to intervene with.
See, according to me, any kind of proposal you go to NCLT, one has to do their homework
Absolutely.
properly, and then they have to establish before the tribunal that how it is beneficial to the company as a whole. Number one.
Correct.
Number two, in particular, when you go for reduction of share capital, unlike merger amalgamations, demergers are all into one basket, whereas reduction of share capital is concerned, the NCLT has to be very careful while approving that kind of schemes. Why the capital is being reduced? Okay, is there any kind of tax evasion? Is there any kind of malified intention of the promoter? Is there all these aspects they have to see? In particular, about when you are going for a selective reduction of share capital, you have to be more careful. Means
Correct.
what? Your homework should be done thoroughly. First of all, you have to decide which way you want to go, under which route you want to go, And after that, you have to also do your homework properly before you submit to the proposal to the NCLT. Because once you submit, at every stage you have to be proactive enough that what kind of questions may come and you answer that in the scheme itself, so that it will be a cakewalk for you. If
Correct.
you are not doing your homework properly at every stage, you will have some kind of impediment or the other, and you have to face the challenges.
Correct. So just to highlight this point, since you said that it should be adequately represented and it should not have the approach of the management should be at trial. I've also seen cases where if it is a specific non-promoter shareholders targeted, वो उनको ऐसा लगता है कि सर मैं I write in the application openly. I say कि I'll be reducing the non-promoter specific shareholders expressly. I mentioned it in the application. Once I send it for their review, the management comes up to me, सर आपने तो एकदम aggressively लिखा हुआ है, expressly mentioning out कि आप squeeze out कर ही रहे हो to the non-promoter shareholder, you are squeezing out. So do you think NCLT will have this concern? मैंने बोला why? If I do not say this, मैं उनको घुमाने की try करूंगा ना, then at every stage I'll have to keep on getting new answers to them.
Yeah, correct.
Rather, whatever I'm doing is very out in public domain that this can be done. So why do I not mention that, and why do I try to hide it or color it up with some other things so that I'll have to answer 10 new things other again to the either to the shareholders or to them. मैंने बोला अगर आप shareholders को भी प्रपोजिशन रख रहे हो, आप वहां पे भी यही एक्सप्रेसली मेंशन करो कि हमारा टारगेट है टू दैट नॉन प्रमोटर शेयर होल्डर्स एंड यू आर इंटेंडिंग टू मेक इट अ होल्डी ओन सब्सिडरी. देयर इज नथिंग दैट यू नीड टू हाइड ऑफ.
That's
So
what I told you. That's what I told you, Deep, that you have to be proactive enough, and you have while you are drafting the scheme itself, that time you
correct,
have to be so proactive, and do your homework thoroughly.
correct, sir.
Then you will not have any kind of impediments. This is precisely what we used to do when I was in Reliance. That scheme, once it is drafted, we used to get it examined internally, externally at every stage, what sort of questions may come up, may not come up, and all. If it comes, how we are going to react to that, how we are going to answer to that, what sort of backup paperwork we have to do for that. All these things we used to do it. Because
Correct.
instead of having the labor pains at a later stage, you have it before only.
Absolutely correct, sir. Absolutely
Yeah.
correct. And that is why, sir, in
Absolutely.
the initial I said that I need my client to synergize within themselves to how are you going to look at the scheme and what are your benefits. See, I have seen many people relying on the consultant, but बाद में क्या होता है, consultant ही गाली खाता है जब भी वो delay हो जाता है. But if I had inputs from your end at the initial part, I wouldn't have to suffer at the later part. And this is a very important aspect that people fail to understand. वो बोलते सर आप हो ना, आप गाइड कर लेना. अरे मैं गाइड कर लूंगा, बट व्हाट आर योर सिनर्जी, व्हाट आर योर एडमिनिस्ट्रेटिव बेनिफिट्स, यू विल हैव टू डिराइव इट फ्रॉम योर टीम. यू कांट से कि सर मैं आप पे रिलाई करता हूँ, आप जो भी को डिसीजन बताओगे मैं कर लूंगा. अरे बट बाद में जब सफर करोगे तो भी मेरे पास ही आओगे. तो रादर यू डू इट इन दैट वे.
So basically, in principle, selective reduction of share capital is allowed. It is under law. You are not doing any operation mismanagement activity to your minority shareholder. It is, and that's why, but yes, it is something selective you are doing. So you have to go to NCLT and judiciary. Act has given the power to NCLT, wide power in case of reduction of share capital. Further, be clear why you want to do that. What is the purpose you want to achieve, which is in the interest of the corporate and the all stakeholders. In the process, NCLT role is that whosoever shares you are going to reduce get a fair value of the shares they are or securities they are holding. Though NCLT does not go into the valuation, how the valuation arrived, whether it is right, wrong, or like that way, because it is to be done with the process and by the professional mention. But it should not be abruptly done, or it is apparently one can make out that there is something wrong and there is no proper process followed. It should not be that way. And fourth thing, your non-compliance should be checked in advance so that there is no issue when this entire process is going on. Yeah, Dip.
Absolutely, you put it correctly, Dipti. One thing is very, very clear. You have to be very, very transparently disclosing the details, your rationale behind it, You have to tell what exactly you want to do it. That is very, very clear. If you put it very clearly, you'll be able to represent. As Deep put it, if you are putting it, then every time you have to try to manage what you are not put. That is the problem. So you have to be very, very transparent. And again, it is legal. It is law permitted, as you rightly said. There is nothing we are doing anything illegally. So that should be the case. That is the thing. The drafting part is very clear, as Sudhakar also mentioned it. He gets it internally checked, externally checked, expert checked. And again, NCLT is not going to question the valuation so long as it is given by the professionals. They will accept it as it is, unless they have a reason to believe any hanky-panky and other things and all these things. Otherwise, they will accept it. They are not going to get into those details. So we have to be very, very clear on that. What you said is absolutely correct.
Yes, Sudhakar sir, you were saying something.
Yes, go.
Yeah,
Yes, go ahead.
Sudhakar sir was saying something.
no, I think he doesn't want.
Okay.
We have 12:40, huh?
Yes, ma'am. So we can take up.
And a lot many questions are there.
Yes, we can take up the questions, ma'am.
It's done?
Yeah, we can do that.
Your presentation is over with?
Yes, yes. Just a bit few of case laws, but that is okay. I can answer those during this. I think there are certain questions that need confirmation, so I'll accordingly highlight those case laws at that point in time.
Yeah, okay.
Okay.
Mr.
Okay.
Bala, start the questions.
Yes. How is the valuation done?
Pardon, sir,
Or
I've
do the
joined.
shareholder? How is the valuation? Sorry.
Anybody here?
How is the valuation done?
Hello?
Hello?
Yeah, carry on.
Yes?
Yeah, carry on. Mr. Bala, carry on.
Okay. Yeah. How is the valuation is done? And do the shareholder have any say in how the valuation done by the company?
If I may take it.
Yeah.
Dev, you can take it.
So how is the valuation done is basically it's through the registered valuer only, and they come up with the best the methods that is the most beneficial for the shareholders. Now this is where I am talking where the company's point of view is very fair in justifiable. Now if the company's aspect with regards to it is to not give the benefit to the shareholders, it's a separate issue altogether. But I am talking about a very scenario where it is a genuine case of the company that they want to provide those benefit to the shareholders. There, the registered valuer only on the basis of the financials decide as to what is the best method to come up with. Now, when do the shareholders have a say in this? At the initial point, no. But after the valuation has been done, after the meeting has been concluded, and if you feel that the valuation is not as per what it should be, then the shareholders have a say at the time of objecting it to the NCLT. So at that point in time, the shareholders can come state as to, but when I say that they have to come up with this objection, this cannot be a frivolous one. This has to be a very studied concept of that valuation. You have to read through it. You have to come up with a very specific objection as to why do you feel this valuation is not fair. And if not the case, what should be the fair value and how should it be computed, then that is not something that the NCLT is going to intervene, but to provide a solution, what they would say is NCLT will then appoint an independent valuer, taking into consideration the shareholder's objection, the company's objections, and then the independent valuer on the panel of the NCLT will then decide what will be the value of it. Then there are no questions asked further. Then the shareholders can then not raise those queries again. So this is basically how the whole thing works.
How do you do in case of the acquisition of the companies through NCLT? I think acquisition merger, we talked last seminar. I think you should refer the recorded webinar. I think so.
Reduction is not there.
It's a mutually decided price. I would be saying.
Are there any extra compliances or provisions for government company?
No, it is something that is in general for all of the companies applicable.
Okay. Can alteration of the AOA and approval of the scheme reduction of the capital be approved in the same AGM or EGM?
This is a more secretarial part. I don't know if I'll be able to answer this. If Sudhakar or Keshav, if anybody.
As far as the reduction of share capital is concerned, it is like a court convened meeting. It is not like EGM or AGM, something like that.
Yes.
So articles of association amendment, these two things should not be clubbed according to me. Number one. Number two, as I have mentioned, I don't know what is the purpose of amending these articles. Unlike Section 100 of the 56 Act, there is no such requirement that the reduction of share capital is to be authorized by the articles in Section 66. So even if the provision is not there in the article, still you can go ahead with that.
No, that decided case is there, no, Sudhakar, starting only in our presentation we
have
covered.
to give that powers.
So article should provide that. So that's why the question is that they don't have power. So whether bring the power
No,
in the same EGM and approve the reduction in the same EGM. According to me, I think it will be not workable because the power should be there. Then the board will move the resolution for reduction and the shareholder.
no, but one thing, 1 minute, Deepti. This is decided by NCLT. You meant to say?
There are decided cases we carried out now in the slide where it
Where they said that authorization is
is
required,
required in articles.
but
So
under the Act it is not there.
yeah, so in that case, see this.
Okay, okay, got it.
So that's why they don't have
There is a
power. They don't have power, so they have to amend for the reduction.
there is a
They are telling that both the things we will do in the same EGM. According to me, also it is not correct because your power article should be amended first,
Then the board.
and then it is given the power.
Correct,
You cannot
correct.
presume that a first resolution is already approved, and that's why I'm going with the second resolution.
But bit beg to differ, but a bit since it's a procedural thing, since law says that you need to take the approval, that is the only thing. It could be at the same time or it could be later on. But since working with a listed company or having a big shareholders, it requires a lot of you can say resources utilization. So to me, it seems like it can be done considering the proper sequencing of the resolution has in place like this, that the first one is the article of alteration of the article, and then second one is the scheme which we are going to propose. It
I,
could be like, yeah.
I understand that point also, and this is always a situation. I'll put it in a precautionary way that it can be
Yeah.
questioned by the ROC and the MCA.
Yes.
That how you presume the first resolution is already approved and already board approved the scheme and already you placed before the shareholder when you were not having power to do this. That can be the questions and you may face it. It may
not
or
only that, as you rightly said, Dipti, unless the article is amended, then the lesser resolution filed with the ROC, the effect is really seems to be taken place or something. It is okay, people have approved it, but the filing procedure is actually also involved. So as you rightly said, yes, opposed to taking a precaution, having a separate meeting is better. Yeah.
next.
There is a disagreement between the company and the minority shareholders of the valuation, and the gap is very large. How can this be resolved?
There is a disagreement between the company and the manager.
The fact of the thing now
This
this
can
to
be
be.
settled amicably between both the parties.
We cannot comment. It is based on the case, boss. Yeah. Next.
What is the percentage of the share capital which can be reduced by the company? I think this you answered already. In fact, Sudhakar said it actually.
By this, so entire share capital can also be reduced.
Correct. What are the taxation implications in case of the shareholder who tenders share in selective capital reduction?
So recently, one judgment has came in Jupiter Capital, wherein Supreme Court has told that you can claim the capital loss. It is a transfer. Extinguishment and relinquishment of right comes under the definition of transfer under the Income Tax Act, and you can be like claim the capital loss. That is what my limited understanding after reading that judgment. Yeah, Bala sir, you can add.
Whether the notice in the newspaper used to be given only after the directives of the NCLT, or it can be given voluntarily at the time of the filing the RSC one.
No. After the admission has been done by the NCLT, after that only the publication can be.
The local language varies
I
from state to
just
state. Yeah,
Mr. Bala, that first application is that we intend to do this action. So, in principle, the court should accept your action that you can do. Then they give direction. Without that, you cannot give public advertising. This is the understanding, common man understanding I'm talking. Yeah.
The local language vary from state to state. That is absolutely right, as Deep puts it very clearly. If we go to southern part of the country, different language. If we go eastern part of the country, it is Bengali. It is in the local language in which the state is actually situated. In one of the case of operation mismanagement case, the NCLT has ordered the company to buy back the share, and the one party issued price. Both the party agreed to this to comply with the NCLT order. The company paid the share buyback money to other party. Being not normal course of the buyback is prescribed under the Act, how the company practically comply with the filing from the reduction of the share capital in the master data. If this case, there is no EGM special resolution, not the money paid from the reserve and surplus account.
So if I can take this up.
This is buyback or this is reduction?
So basically, this is a NCLT driven order. So now, with regards to
NCLT has given the order buyback the share.
correct.
Yeah.
So now, in this case, when it comes to the master data part, this has to be provided to the ROC in specific
ROC,
terms, along with the order that as per the directions of the NCLT order, we are doing this, and this is why the rationale behind it has to be explained to the ROC at that point, and
Yeah.
accordingly, ROC will do it.
Yeah, you require personal meeting. Explain them that it is an NCLT direction. As per
Correspondence
the
with the ROCs at the primary.
yeah, next.
How the process goes in case of the reduction of the existing capital and the infusion of the fresh capital in case of NCLT acquisition.
How the process goes on in case reduction.
How is the process goes in case of reduction of the existing capital and infusion of fresh capital in case of the NCLT acquisition?
So this, what he's talking about is at the time of scheme of merger. I think that in case of that, are you talking about, Mr. Nagar?
The question is not clear.
Because this
NCLT acquisition is.
I am not very clear from this question. Yeah.
This is basically wherein the composite scheme can be drafted out, wherein you reduce the capital, also you infuse the more one, and accordingly everything will be then reflected into a share exchange ratio.
Or might be it would be referring to the IBC, wherein you are going to reduce the capital and then.
That is all governed in the NCLT
Yes.
order. That
Yes.
when the resolution plan is get approved,
Yes.
you have to ensure that order is proper. That is very necessary. Yeah.
Deep, somebody is asking, can you please show page number, page with the step 4? I missed it out.
Just this is the one.
Yeah, he's talking step 4. Yeah.
This is rule 4. Step 4 or rule 4?
He's talking step 4. He's saying step 4.
Step 4 is here.
This one. Basically, for meeting.
Yes, Ruchika, you are there? Ruchika, it is for you. Yeah, Ruchika, it is for you.
So basically, issue of notice to the creditors and then publication of notice, and you file affidavit for this dispatch and publication. That is the point. Yeah. Next.
In all this simple matter, what I feel is the NCLT, ROC, and all the judiciary agencies as a proposed transaction is full of muck, and it is done with a malicious intent of the shareholders or stakeholders, directors. Is there any way this present government, who's actually do much tom-tom about ease of doing business, can be presented the case by the ICSI and smoothen the process and do away with the difficulty and the integrity process, lengthy process?
No matter what you say about the government or the process, but you'll have to abide by it. We have no other option.
See, we have no option, because when we go to the NCLT, how they look into it, how you are presenting it, what is the things have come, what is in their mind, nobody can say that. Because they are being a judicial authority, we'll have to comply with it, that's all. So that is why Sudhakar puts it very clearly, we'll have to do our homework very thoroughly. We'll have to be prepared. Expect the unexpected things. Even Deep also touched upon many things. When you are working with the big 5, big 4, what happens, etc., and other things. And also, we'll have to be prepared for that. There's nothing much to complain about it. We are at the receiving end. We'll have to obey by the orders of the NCLT. Yeah. Do the person whose shareholding is actually getting reduced, his company to attend AGM and give reason for reduction?
This we discussed that, even if you not attended the meeting,
right to object still available.
correct. The right to object is still available.
If the reduction is proposed by the wholly owned subsidiary of a listed company, are there any disclosure obligations of holding company as per the LODR or any other regulation?
This, I think, should not. I mean, this is a very secretarial part, but there I'm not sure of it.
Yeah, wholly owned subsidiary LODR disclosure will be there, right, Sudhakar? Because it affects the price.
If it is going to have any impact on the share price
Yeah,
of the
share
holding company,
price.
then only, otherwise not required.
In case of a listed entity, do we need to get the NCLT directly after taking approval of the shareholder for reduction of the share capital with the waiver under regulation 37(6)(b) of the SEBI LODR regulation with regards to obtaining NOC from the stock exchange?
No, there is no waiver as such.
No waiver. That NOC you have to obtain.
No matter how much time it takes, but you'll have to do it.
NCLT
Mr.
will
Sudhakar suggested that Mr. Sudhakar suggested that a 100% reduction of the share capital is possible. How does this work in reality? Should the company have the minimum share capital as prescribed by the Companies Act?
Yeah, Mr. Kesav mentioned that, I think. So, Mr.
Maybe
Kesav.
Sudhakar sir has said it that entire share capital can be
I
for the
only
sake
have
of
mentioned that. Suppose sometimes it may so happen the company wants to become a guarantee company.
yeah.
In such case, it can happen because
Yes.
that company can go for 100% reduction of share capital, and after that it can go in becoming into a guarantee company. In one scheme itself, you can put the entire thing.
Yes. And it is for the sake of saying it, the way it has been like said it. Yeah.
Yeah.
Remember a case a decade ago, Colgate India reduced 9 rupees out of rupees 10 face value reduction of the capital. It was a great turmoil positively. Those reduction of the capital base was very important role. A good subject today at the webinar. Somebody is appreciating it. Okay. In selective reduction of the share capital, if the shareholders are getting more say to examine, say 500 for rupees 100 share, what will be the tax implication for additional 400 as they are getting up this long
long-term, short-term capital gain or dividend?
I think Keshav will answer this question when it is come to the tax implication. Is for direction is side.
Still, it requires.
I think Dipti, with this we come to the end of the question. There is no more chat box questions.
Oh,
People
sorry,
raise the question.
Mr. Bala,
If they want
Mr.
to raise
Kesav was telling something. Yeah,
I was saying that still there are more nuances to it, considering it would be how it would be treated the long term, the short term, without consideration, with consideration. So this requires a separate, you can say, webinar for discussing the nuances from the Income Tax Act.
Yeah. Okay.
Would you like to answer, raise the questions? They can raise their hands, please. Yeah, currently.
Yeah. I think no one is there.
I don't see any hand risen actually.
Yeah. I think we can close the webinar.
Okay, if there are no questions, then we can close the webinar, I think. Yeah.
Okay. Thanks, everyone.
Thank you very much.
Thanks for your participation. Thanks, Dick, for wonderful presentation and answering all the questions. Thanks, Mr. Keshav, for your very introductory, detailed introductory note, giving, creating a pitch for the entire presentation and putting an add-on in between the valuation. And thanks, Sudhakar, Mr. Bala, for your inputs and an experience. Thanks, everyone. See you all next Saturday. Thank you.
I would like to express my sincere thanks to Deep for valuing his, practical knowledge, what exactly happens as the NCLT, what precaution we'll have to take and all those things. He has given the very, very insightful information while going for the scheme. So he has very nicely presented. My great appreciation to him.
Yeah.
Thank you. Thank you so much.
Thanks, Keshav. Thanks a lot.
Thank you so much, sir. Thank you. Thank you so much.